In an aggressive move, District Attorney Fani Willis and Fulton County prosecutors have proposed a March 2nd, 2024 trial date in the Georgia prosecution. If that date is ultimately agreed to by Judge McAfee, who's presiding over that case in Fulton County, that would mean Trump spends the first half of 2024 inside of a courtroom. Remember, it's possible that we may see as early as a January 2nd, 2024 trial date in the federal case regarding his efforts to steal the 2020 election in Washington, D.C., a March 25th, 2024 trial in the Manhattan DA case regarding Trump's hush money payouts to Stormy Daniels, and a May 20th, 2024 trial in the stolen classified documents case. Somewhere in there we'll also see another trial on behalf of E. Jean Carroll for abuse and defamation, all of which is to say, I don't know if Trump was planning on campaigning from the courtroom, but that's going to be his reality. Now, Trump, for his part, is seeking delays in all of these trials, and the intent is clear. He thinks that if he can push these trials until after the 2024 election, that he can win the presidency in November, install a lackey at the top of the DOJ, and that person would then withdraw the DOJ from its own prosecution of Trump. Of course, that wouldn't help him in Fulton County, which is a state prosecution, and yet you wouldn't be surprised to learn that Trump and his allies have already begun taking steps toward having that case removed to the federal court system. Mark Meadows, Trump's former chief of staff, filed with the court on Tuesday to move the suit to federal court just one single day after he was indicted in Fulton County. Only, small problem, this isn't the jurisdiction of the federal court system. The executive branch of the federal government, where Mark Meadows was a part, plays no role in the administration of elections, and that's by design. It's left up to the states to administer their own elections, and then for Congress to certify the elections. And so the idea that the White House chief of staff is going to convince the federal court system that an issue that he has zero jurisdiction over, an issue that his entire branch of government is purposefully excluded from, should somehow be removed from a state court system is really one of life's great mysteries. I would say good luck, but I wouldn't actually mean it. Now, in terms of the likelihood of this case being removed to federal court actually happening, I discussed that possibility with my Legal Breakdown co-host Glenn Kirshner.
It would be a federal court judge that Donald Trump's lawyers would file a motion to remove the case with. That federal court judge will decide whether there were, such sort of unique federal circumstances. For example, if Donald Trump was acting entirely within the scope of his official presidential duties, then the case would have a chance of being removed from state court to federal court. The last thing, in my opinion, any judge would conclude is that trying to overturn the results of a presidential election is somehow within the scope of the duties of a president of the United States. I actually think there is very little chance, perhaps no chance, that this case will be removed from Georgia State Court and be transferred over to federal court.
So look, Trump and his allies will inevitably try their hardest to get this thing moved to a court system where they could then undermine it if Trump's Hail Mary play of winning the presidency materializes, but recognize what they're doing. Even amid a raft of prosecutions predicated on his conspiring to undermine the democratic process and the law, still, at this very moment, he's continuing to undermine the democratic process and the law. Please, someone, find Susan Collins and let her know that I'm starting to think that Donald Trump might not be learning his lesson. Now, in fairness, I do want to discuss the likelihood of this case actually going to trial by the proposed March 2nd, 2024 date. Remember, the Washington, D.C. case narrowly focused on Donald Trump for the express purpose that it was built for speed. Jack Smith even included 6 other unnamed co-conspirators in the indictment who very clearly have legal exposure, but they purposefully weren't indicted because the presence of even one more defendant, to say nothing of 6, would prevent this case from being prosecuted quickly, which is very clearly the goal. And yet still that case will only go to trial in about 6 months at its earliest. So the notion of a sprawling RICO case with 19 defendants could also go to trial in about 6 or 7 months does seem to defy reality. But there are 2 different responses to this, and they're both valid. First, here's Glenn Kirshner's response.
I think some of what DA Willis said in that post-indictment press conference was aspirational, but perhaps not realistic. When you have 19 co-defendants, you have 19 defense teams representing those 19 co-defendants. You are going to have so many scheduling conflicts. You are going to have so many motions filed that need to be resolved by the court that I think it is extremely unlikely this case will go to trial within the next 6 months. I could see it perhaps going to trial within a year, within 18 months, but I think 6 months is pretty unrealistic. Similarly, she also said she'd like to try all 19 defendants together. A couple of observations about that. First of all, by the time the trial rolls around, I can promise you it will not be a 19 co-defendant trial. I'll call on some of my own RICO trial experience to try to explain why there's no way you're going to have 19 co-defendants going to trial. I had a RICO case where we indicted dozens and dozens of defendants, 30-something defendants in all. And at the end of the day, all but 13 of the defendants pleaded guilty, many of them with cooperation. Some took what we call soldier pleas, where they pled straight up to everything and were willing to die in prison rather than snitch out their fellow, RICO crew members. But we ended up going to trial against 13 defendants. Here's the other thing I'll say. 13 defendants is a lot of defendants to pack into a courtroom. I can tell you in the courts of Washington, D.C., the maximum number of defendants that can be tried in a joint trial is 6. Why is that? Because the United States Marshals are the ones who provide courtroom security, and they actually call the shots, not the judges, when it comes to the maximum number of defendants that they can safely provide courtroom security for in a joint trial. And the U.S. Marshals, for as long as I was a prosecutor in the courts of Washington, D.C., said 6 is the limit, because we need marshals in the courtroom to protect the judge and the court staff, to protect the jury, to protect the prosecutors, to protect the defense attorneys, and to protect the audience members.
But here's another point worth mentioning, courtesy of my Democracy Watch co-host, voting rights attorney Mark Elias. We saw in the D.C. indictment, for example, that there was only one defendant, and that was Donald Trump. This indictment in Fulton County has 18 other defendants here, and yet Fani Willis wants to go to trial quickly. How do you square those things? Doesn't a sprawling RICO case open the door for huge delays when you're dealing with so many different people?
It can, but I'll tell you, this RICO charge in Georgia has a 5-year mandatory minimum. So I think you're going to see some people flipping like burgers at a fast food restaurant. So, it's easy to start with 19 people being very brave on day one. Let's see where they are a month from now, how many defendants there are. Not a lot of people want to go to jail for Donald Trump.
So if it does end up being 19 defendants, then will it happen in March of 2024? Unlikely. But that's only assuming that there are 19 defendants at the end of this. Again, as Mark said, when it becomes clear that these people are effectively going to be trading in their freedom for some blind fealty to Donald Trump, we could probably expect to see some shifts in priorities. Or, put another way, some of Trump's co-conspirators are going to flip like burgers. One thing is certain as far as Fulton County is concerned, these Georgia prosecutors are looking to move as fast as humanly possible. And this isn't their first rodeo. Fani Willis has experience prosecuting RICO cases. And clearly, they understand the risks of allowing Trump the ability to delay. This is an issue that should be litigated, in full view of the public, by the way, before voters head to the polls, because the defendants in this case pose a clear and present danger to those very voters. Trump had no issue committing these crimes. Now comes the part where he answers for them. Before you go, I need some help. Please subscribe to this channel and do your part to help grow the progressive media ecosystem. I don't do sponsorships or paid ads, I won't ask for money, but just subscribing to this channel goes a really long way, and it helps get the message out to more people. The subscribe button is right here on the screen. You can also subscribe to my Spanish language channel, which I made to reach those crucial Spanish-speaking voters. That link is on the screen too. And finally, if you want to listen to my audio podcast, you can follow that link as well. Thanks so much for watching.